Alright. So, may topic ba tayo? Okay pa, yung focus natin pa where consciousness of the legal document. And as well, authority will receive Emmanuel Tago, senior legal associate of Argao, who is currently stationed at the UP Manila Legal Office to discuss about legal documents.
No, mas malinaw na po ba? Ayan. 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 So, before I start, gusto ko lang i-heads up. I think this is a very good news sa lahat ng researchers. With the new Government Procurement Act, that is RA 12009, there is a new mode of procurement, which is direct procurement for science, technology, and innovation. So, uh, we have to wait for the IRR, but basically, it would streamline all of the processes na to the point na stretching the argument kung ano ang itulong ng researcher, yun yung gagamitin. So, I think that is a welcome development for people. So anyway, for the main topic, so preparatory legal documents. Actually, I prepared a very brief slide, slide deck for basically what we want to, what you would have to present or submit preparatorily are those documents that show first on the part of the researcher the legal tie of the researcher with the university. So that is why is specifically in terms of trial agreements requiring appointment certification, but we do accept yung other equivalent documents. And for the other contracting party, we also require of the proof of their juridical identity or capacity. Kung sa Pilipinas, that is the GIS, the distinction, or other equivalent documents for foreign entities or agencies. And then for this is the next is for trial agreements, yung research documents related to legal agreements, protocols, and steps. So for a comprehensive list is the TP and alone checklist. So I have basically divided the legal arrangements or agreements relating to research into three categories. First is the funding agreements. Second, research agreements, which pertain to the implementation of the research. Lastly is for procurement related documents. So as you can see, there are different kinds. So funding agreements, it would generally the distinction would generally be as to who will provide for the funding. If it is institutionally sourced, it could be that is through memorandum of agreement or also for GFA's government funding agencies, memorandums Indian. If foreign source or private source, that is through foreign grant agreements. And I also included yung agreements, funding agreements, which include a financial intermediary. Ano po ito? As you well know, these are agreements that involve a third party or a third party which manages the fund from the funding agency or the funding entity on behalf of the researcher or the university. Next is research agreements. These are RCAs, memorandum agreements for understanding, CTAs, material transfer agreements, and other unsecured agreements. NDAs are non-disclosure agreements or CNDAs, confidentiality and non-disclosure agreements. Meron din tayong tinatawag na mutual non-disclosure agreements and NDAs. These agreements are entered into if proprietary or confidential information is involved dun sa research. Ano ba ang mga examples? We'll go through that later. DSA, DUAs are data sharing agreements or data use agreements. These are agreements that researchers or the institute enters into if the research involves the use of private information or personal information of a person, Filipino person specifically. So, kailangan mo yung mga moving on, procurement, terms of reference or text specs, technical specification, and procurement contract. So basically, these are the three kinds of legal arrangements that researchers will encounter in conducting their research. So, importance. Actually, lahat yan, first and foremost importance is to establish the legal tie between the researcher, UP, and the third party, either funding agency or collaborating institution. That's the first and foremost purpose to establish a legal tie to make enforceable the legal obligations under the contract. In legal terms, we call that with for funding agreements, you could see identify the source of funding and purpose, earmark as to when, how, and what purpose the funding is to use, provide for the consequences for breach of obligations and legal compliance. Actually, the same din yan sa research contracts or research agreements. Ang medyo pinagkaiba lang ay yung the first and foremost purpose sa procurement documents is, of course, when it involves government funding, is to comply with the government laws. So, moving on. Yeah, examples of legal documents and research. So, if the document or the legal arrangement establishes the framework between the parties, ano po ibig sabihin nun? If the arrangement is to identify what areas of research are involved, who will be participating in the research. Basically, it's a general framework. The most appropriate legal arrangement is a memorandum of understanding. They say na hindi naman binding ang MOU. Well, it depends on the nature of the contractual provisions. But the purpose of an MOU is to establish the framework for collaboration and generally in MOU needs subsequent agreements to enforce the provisions. Not that they are not binding, the provisions are not binding, but they need subsequent agreements or arrangement to determine what or when. Kumbaga kung paano gagawin yung pinagkasunduan. So MOU may pinagkasunduan, subsequent arrangements, agreements, those are MOAs, Memorandum of Understanding, kung paano gagawin yung pinagkasunduan. NDAs protect, sabi ko kanina, confidential data or proprietary information. So, yeah. It may also involve the protection of intangible research materials, intellectual property, software or software licenses, data protocols, and procedures. As opposed to tangible research materials, NDAs, so they are classified generally into biological and non-biological materials. So NDAs for that. IP agreements for ownership and sharing of copyright or patents. So the question one of the questions raised, or one of the questions I encountered is, pwede bang yung mga provisions na yun sa isang document or separate document? Actually, it depends upon the parties or for convenience. Pwedeng separate agreements if the parties cannot agree on the specific phases or specific portions. So, paputol-putol separate agreements. Or it could be embodied in one agreement. A good example of this are trial agreements, clinical trial agreements. They are comprehensive enough to include provisions for research implementation, funding process, budgetary and financial costs of the apprentices. So, pwede po yun. That is subject to the agreement of the parties for convenience. So, how would you identify the appropriate legal arrangement? I have only enumerated three guidelines for strategies. First is identify the purpose. So, ano ba ang purpose ng agreement? Para ba makakuha ng pondo? Para ba makipagkasundo sa pang academic institution on what research areas are to be developed or what are the research areas involved? Will it establish clear obligation? Ano po ba ang clear obligation? An example of which is the project leader will or the principal investigator will faithfully comply with the protocol. So that is a clear obligation. Tapos, is it like primary or incidental agreement in relation to the research? So as I've shown you kanina, primary agreements are the memorandums in clinical trials. And similar to that is anything that is in furtherance of that agreement for that purpose. MTAs, material transfers, MTAs, non-disclosure agreements. Determine what needs to be accomplished. How will the purpose of the agreement or arrangement be achieved? Who should be involved? So number two, oftentimes kailangan ng consultation or intervention ng legal office kasi one of the questions raised is paano if the research is between UPM and UPM unit and another different unit. Dapat ba MOA it can be enforceable through a memoranda or through a non-procurement TOR, terms of reference. So, pwede naman ganun. So, will be involved kung if it is the UST, I think they have a standard agreement for the UST GID. So, yun ang sinusunod natin. So, ayun, what needs to be accomplished? And lastly, for agreements with funding elements, how will the funding be efficiently utilized? Itong 1, 2, 3, 4, these are subject to the restrictions of law or the restrictions placed by the funding agency or entity. So will the funds be transferred directly to UP? Kailangan ba gagamit ng financial intermediary the foundation? Will it be directly transferred to the researcher? There are instances na nangyayari ito. If it nangyayari ito sa kapatang funding agency and I think it's a foreign agency, foreign funding agency. So letter D, what is the source of funding? So those are the three simple guidelines to determine the legal arrangement to as the legal counsel and research, as much as I can, I do accommodate consultations. So, actually, sabihin ko na rin sa inyo, I would prefer it na kung bago mo ipasa sa legal yung document, kung may malinaw, kung there are things that need clarification, I would really appreciate it if you would request for consultation sa akin. Para kasi mas mabilis, para pag dumating na yung document sa akin, uh, quick review endorsement na lang, tapos ano na, papaapprove na. So, personally, I don't like yung pabalik-balik ng documents. So, as much as possible, I reach out to researchers, to the project staff kung ano gagawin. So, ayun, uh, para lang mabilis. Consequences of non-compliance. I hope you would indulge me and patawarin niyo ako, pero this is parang to make everyone aware kung ano ang pwedeng mangyari. Not that it will happen, but it could happen. So, consequences of non-compliance. 3, contractual liability, administrative liability, criminal liability. Examples. Primarily, this depends on the contractual provisions or the stipulations. So, ano ba yung mga examples ng disqualification from future funding from the funding agency? Revocation, solid yung unspent na pera. In some cases, payment of damages. Sa nakikita to, we often see this in what we call the old harmless clause. Parang something goes like that. The project leader and institution agreed to defend harmless funding agency from all suits. Something like that. So ano ibig sabihin nun? Ay, ibig sabihin lang doon, pag nakatulan si funding agency, papasa nila sa project leader or the institution. Administrative liability depends on the nature of non-compliance. So I cannot give any specific administrative violation, but depending on the gravity, it could be an admonishment, which is not really penalty, is warning lang, reprimand, suspension. The gravest of all is dismissal from service. Hindi ko naman po kayo tinatakot, pero ito lang ay ang mga posibleng mangyari. It really depends on the nature of the liability or what the researcher public staff did. Example, hindi nagbayad or ilang taon nang hindi liquidate yung cash advance. Depending on the facts given, pwedeng reprimand, suspension, dismissal from this. Pero, as with the brief time that I have been with UP, I think very accommodating naman ang university sa mga researchers kasi naiintindihan naman na talagang nakakadala for various reasons. But I just want to give a heads up for everyone that these are the possibilities, possible liabilities. Criminal liability, meron din po. Again, depends on the nature of non-compliance. Pero nabigay kong example kanina, unliquidated cash advances. Under the law, they are considered loans. However, if public funds are involved, the liability may be in the form of failure to earn accounts by an account of that is 218 rather of the RPC. Meron pa naman, it could be also a violation of Section 3A of RA 309, that is the Anti-Capital Practices Act. Pero hindi naman para matakot kayo na makasuhan, but just to be informed. So, ayun. I think this is my last slide. Enforcement of these remedies are cumulative and not alternative. Ano pong ibig sabihin nun? The outcome on one remedy does not foreclose enforcement of the other remedy, the other two remedies. So they may be resorted to independently from each other. So I think that is what it's time to say. 30 minutes. Thank you. from sa research agreements, one of the reasons na, especially on clinical trials, one of the main reasons bakit nagkakaroon pabalik-balik is on the insurance laws. Kasi we have to consider that the authority of the chancellor to enter into research agreements is always restricted that these do not entail additional or budgetary outlay. So kung meron ganon that the other party requests obliges that UP procures or gets insurance specific for that stuff that is considered a special budgetary outlay. So, yun yung mga, tawag one of the provisions that we maybe the reason why it takes some time. So we enter into discussions, negotiations with the CRO or sponsor, CRO na to modify these provisions para comply sa delegated authority ng Union Chancellor. Okay. So, ayun. Thank you.
Your perfect balance. Yes, mag-open po kami ng at least 2 questions din po for Attorney Tacom. And meron po ba questions? Yes po, please proceed then.
Hello po, good afternoon. Good morning po. So, question lang kasi nabanggit po kanina ng SPD na when it comes to dahil crucial po yung ngayon crucial yung MOA and conformance sa release ng budget. So parang sabi nila kanina if from their end dumating na sa kanila yung documents, the release of the MOA or the conforming to the project team, it would take a week. Tapos parang inana nila kanina na it would be a big help to them as well if yung Manila could return the favor na to accomplish the same within a similar time period. So, ang tanong ko lang din po is, what is the usual turnaround time po of review and release of documents from legal kapag nagpasa po ng MOA or conforming, since based from experience, it would really take more than a week. And very crucial yung, very crucial na banggit kanina, very crucial siya sa release ng budget.
I think this is in the UVM legal charter. The standard turnaround times, if I am not mistaken, for PORs 15 days. Tapos, contracts, I think it's 21 before. There's something like that. But, kasi ako yung, sa akin kasi dumadaan yung mga research contracts and I try to undertake na kung kaya kalahiin yung report kung mailabas sa well and good. Ayun.
Other question po.
Private connected with the first question. You said before kanina po na you can check the documents ahead. Can we email it po ba? And how long does it take? Kasi kung sinabi niyo po na within 15 working days, pag in-email po ba, mas mabilis po siya? Thank you.
Answering your last question, yes. Answering your second to the last of the first question is yes. I think don't available naman yata yung email ko. Just what they do is they email UPM legal and then naka-loop in naman kami so everything nandun. So pag nakita if it's research related documents, ako na yung sumasagot. So
15 working days po.
I don't think it will reach that.
Kasi, para lang po na hindi magpabalik-balik yung documents kasi yun talaga yung nagiging problem ng mga researchers na laging nagpapabalik-balik yung mga documents na na-signan na tapos bumalik, tapos ilang days na naman, bumalik na naman sa dito. And nag-iiba din yung compliance minsan eh, na yung una na-comply na and then pagdating again dun sa second na compliance, iba na naman siya. So yun lang yung nakita kong problem din ng mga researchers.
Follow up. I cannot speak dun sa na compliance, parang compliance. That would always be case to case, depends on the nature of the document, was for what purpose. But yeah, don't email nyo
Mhm.
for advanced review sa legal. Ako naman yung sumasagot.
Thank you so much.
Yun po. Yun. For other questions po, meron po, sige, last na po sa kung meron po other questions, pero hindi po isulat na lang po sa papel, kasi bigay niyo na lang po bigay niyo na lang po sa registration natin.
Last question. Doon sa unliquidated funds, sabi naman si criminal, pag sinabi natin criminal, ano yun? Ikukulong siya or magbabayad lang siya ng penalty?
218 is specific to failure to render an account. So kumbaga, kaya ko binanggit yun kasi that is a specific instance that could apply sa project leader kung nag-cash advance siya. So to answer, sir, is depende sa judge, either or. I think if I'm not mistaken, that is friction correctional, which is 6 months, 1 week to 6 years, or fine 40,000 to 1.3. Again, that depends sa judge or sa facts of the case. Pero ayun, I don't think naman na magkakaso ako. I mean, wala pa naman ako so, kasuhan pa lang. Pero that is a possibility. That is a possibility that could happen. And just reading the law, pero reading na naman.
Thank you po sa time, sir.
Contracts are reviewed as hard copy. So since you said that they can initially send an e-copy, then perhaps also in the context of ISO, then perhaps the legal office or the RGAO should have a process flow of reviewing soft copies of documents prior to the submission of the hard copy for final checking. Don't have that process flowing in our hands. So both, I think, correct me if I'm wrong, but that's as far as I know. There's no process flow in the legal office, no process flow in the RGAO, legal representative. So we should include that. And we have to inform everyone that we will now accept soft copies of documents for initial review. Magpabalik-balik man din kasi yun. At least, soft copy na lang siya. Kasi hard copy, you need a physical, you need your body to print up to legally. Just to submit a document which only has sometimes a sentence na correction. So we need that practice flow.
Yeah, thank you for your insights po sa legal documents po. Thank you po Secret Police Station. Certification.